Court of Appeals, Division 1 is now in session.
Please be seated. Thank you for being here. We are hearing our case 1CACV 18-0486, ACLU Arizona versus ADCS. Each side will have 20 minutes to present their argument. Appellant, you may reserve as much time as you like for rebuttal, but you have to keep track of that yourself. That's why we have a clock at the podium for that purpose. We are recording the argument both in audio and video. We've also started live streaming the arguments in this court. So when you begin your argument, please identify yourself and your client so that if we listen and watch the argument again, we can keep everybody straight. We've read the briefs, we've looked at the record, we've conferenced the case, so we're familiar with the facts and the law. So when you begin your argument, just launch right into the things that you want to talk to us about. Counselor, you may begin. Oh, I'm sorry. You guys.
Yeah, we did this last time.
I'm used to being on the other side of things.
You guys are on the opposite side.
I apologize, Your Honors. My name is Dawn Williams, and I represent the Department of Child Safety. And we're here today because of an award of attorney's fees in a public records case that the department believes the trial court made a substantial error of law that led to an abuse of discretion, both in finding that ACLU had substantially prevailed in the matter below, and also in awarding the entirety of the amount of the attorney's fees, given the percentage of the litigation that was devoted to the relief they actually obtained. And so for those reasons, the department has sought review in this court, and particularly in light of Division 2's recent opinion in the Paradigm case, it's our position that this matter needs to be remanded or at least reversed or something done to address this inequality in what transpired in the court below. Particularly with respect to whether or not ACLU had substantially prevailed below, it's the department's position that they did not. They had sought, I believe, 171 different documents or pieces of information, and ultimately were found to be entitled, both by the lower court and by this court in its prior opinion, to be entitled to only about a third of those. And the remainder of the litigation, which occurred after the first 2 months of the case when they received the last piece of that information that they were entitled to receive, all of the rest of the litigation did not result in any significant benefit to ACLU.
Okay, so how much was turned over after our decision?
After this court's decision?
Yeah.
None. There was no additional information that they were entitled to after this court's decision. And that's what this court affirmed the lower court's finding. And so they have never received any more information after, I believe it was 6 weeks after the initial demand letter, that they received all the information that they were entitled to receive. They have since claimed that because this court found that Childs, the department's electronic records...
Sorry, let me stop you for a second.
Sure.
Because your statement there didn't comport with my recollection of the record. You said there was 6 weeks from their initial demand letter. They didn't receive any more documents after that?
The documents that were produced, let me double check my dates. I didn't put that on my cheat sheet. I I know that it was within a matter of weeks of the initial demand letter that the department produced those post-litigation records, is what they were called.
But that's not from when the initial demand letter, that's from when they filed the action.
Well, the initial demand letter was sent just, I believe, a matter of days before the filing of the initial action. So there wasn't a great deal of time between the demand letter, unless you're talking about the demand letter in January. There was a demand letter in January, which the department acknowledged it received but had not responded to. Then there was a second demand letter in May.
So
that
it's
may
the
be the
second
source of the
demand,
confusion.
okay.
Yes, I'm sorry. I apologize. I forgot about the first one in January. But I'm referring to the one in May that the department did respond to and was the catalyst for the production of those post-litigation
But it wasn't
documents.
just that you failed to respond. They actually followed up, tried to get some types of response from you between January and May, and they didn't.
There was the demand letter in January, then 2 more records requests followed after that, and then after that, nothing until the letter in May.
Okay.
And that's when it came to the department's attention that the department had not responded to the January request and began assessing what it could and could not provide in response to those January requests, as well as the outstanding May requests.
What was the cause of the delay in coming to DCS's attention that it hadn't responded?
Well, in October of 2013, before that was the last time that the department provided disclosure, it was producing the documents requested on a rolling basis with ACLU's agreement. And in October, the department discovered that there were approximately 6,000 cases that had not been investigated for potential allegations of child abuse and neglect. And so obviously that was a huge concern. And the department went to what they called an all-hands-on-deck approach to addressing those 6,000 unaddressed cases to make sure that those kids were safe. And so the department staff were working overtime. They were working, they pretty much pulled anyone and everyone into investigating those cases to make sure that issue was resolved. As a result of that issue, the department ultimately was completely overhauled. It was disbanded and reinstated as the Department of Child Safety as a standalone agency rather than an agency under the Department of Economic Security. So there was a lot going on between October and the department's final iteration in April of 2014.
So did all other work cease during that time?
It didn't cease entirely, but the focus certainly shifted. So particularly once the governor announced in January at her State of the State address her intent to dismantle DES or CPS from DES and create the new agency, the focus, at least in terms of the department's what they call the Records and Statistics Unit, was in providing information to the governor and the legislature in trying to determine how to do that restructuring and how to enable the department to both meet its obligation regarding those 6,000 cases that it was still trying to process, as well as keep up with the new cases that obviously continue to come in on a daily basis throughout this time period.
Is that a legal justification for not responding? That you had things that the department deemed to be a higher priority?
Well, the department acknowledged that it simply did not notice the January initial demand letter. That at that point it was unclear which agency, the new agency that the governor had established, an interim agency, or the Department of Economic Security. And so there was a miscommunication in terms of which agency was going to respond to these types of public records requests. And so it fell through the cracks, and the department has always acknowledged that. The issue then becomes whether the department's production in response to that request was timely under the circumstances. And although the department concedes that it was not appropriate to not respond to that January request immediately upon receiving it, the department does present that its response to the request, once it came to the department's attention, was prompt under the circumstances.
But our standard, I'm sorry.
Wasn't the department responding, though, to other requests from the legislature during that time?
Predominantly to the legislature and to the governor's office while they were doing the restructuring. And then there are mandatory federal reports that are required for the department to secure its federal funding, which it relies on to provide services to children and families. So those reports continued to be addressed and generated as well.
There were other requests, it was just this one fell through the cracks.
I'm not sure if there were others. That wasn't a part of this litigation, so
But
I
I mean, in
don't.
terms of, there were other requests that were responding to from the legislature. they were doing. They were still able to do this type of work.
Right, yes.
They just didn't respond in this instance.
True, to some extent. The department there was also evidence presented. The department's records and statistics unit was very understaffed during this period of time. And so responding to the demands of the governor and legislature was particularly onerous during this time because they lacked the resources to be able to do this increased amount of reporting, increased over what was typical for the department.
And our standard review on that is abuse of discretion. So we would have to find that, considering the facts, including the evidence that the department was responding or providing data to other requestors, not necessarily FOIA requestors, but legislature, et cetera, we'd have to find that the Superior Court abused its discretion in concluding you guys were on time.
In determining whether the department provided its responses promptly, yes. But in terms of
what would lead us to say that that discretion has been abused?
Well, the primary issue here is whether the court properly considered all of the factors, particularly the factors that were set out recently in the Paradigm case, in terms of determining whether ACLU was entitled to an award of attorney's fees.
Well, I'm focusing on the first part, which is the prompt production. So I read Paradigm more as relevant to the kind of substantially prevailing.
Right.
So are you done with prompt production? You want to move on now? Because I don't want, you've only got 10 minutes left, so
sure.
I don't want to.
The department's position is that the lower court found that the department's production of documents between the first request in May 2013 and October 2013, when the department stopped providing those records, was timely under the circumstances. The court also found that the department's response to the two January requests for documents that were produced post-litigation were also timely under the circumstances. So really the only issue is whether the documents, I believe there were 2 of them from the initial May request, were produced timely under the circumstances. And it's the department's position that given everything else that was going on, those were timely given the constraints.
When you say 2 documents, it's about 500 pages, right?
No, that included the January responses.
Okay.
So,
but those were all in the category of post-litigation responses
correct.
That we sent back on our prior remand.
Correct.
Okay.
But as I mentioned, it's the department's position that the real issue here is whether or not ACLU substantially prevailed. Even if they prevailed on the issue that those May responses were not prompt under the circumstances, they still did not substantially prevail in the litigation as a whole. ACLU has tried to claim that this court's finding that Childs is a public record was a win for them, but that was not an issue that was being litigated. If you go back and look through all of the pleadings, there is no request by ACLU for a finding that Childs is a public record. Their request was for DCS to be ordered to provide the records that they had requested, and that was repeatedly denied. DCS in its pleadings has never said Childs is not a public record, because that has never been the department's position. In fact, the information that was provided to ACLU and to the legislature and to the governor and to any other public records request necessarily has to come out of Childs unless it's a hard copy document. Childs is where everything resides. There's no other information to give but information from Childs.
As I read the record, DCS had disclosed thousands of pages of documents
Yes.
from Childs
Yes.
prior to the litigation.
Yes, absolutely. That's where the information came from. So the department has never claimed that Childs as a whole was not a public record. The issue was, were the requests made by ACLU for public records, or were they for a manipulation of data? And what could the department provide while maintaining necessary federal and state confidentiality? And so the department was unable to simply say, here's our database, go find what you want. For several reasons, partly because it's a very convoluted and outdated database, but also because of the nature of the confidential information that's contained in it.
I noticed that when you were making your statement a second ago, you emphasized nothing in DCS's written pleadings saying that Childs is a public record. I know the ACLU highlights 2 statements one made during oral argument by your general counsel and one made during testimony by your, I believe it was the director.
Yes.
Would you respond to those?
Absolutely. With respect to the statement by counsel, I think if the court reads the entire transcript of the colloquy between counsel and the trial court judge at that point, you can see that counsel was not saying it. All counsel said was, is it a public record? So the question is, what was he referring to when he said it? ACLU is saying that he was referring to Childs as a whole. But if you read the entire colloquy, you can see that what he's saying is the remainder of the information that they were requesting, the entire piece of information that was being litigated was not a public record. And if the court found that all of those outlying requests did not constitute public records, then the inquiry was over. And that was what counsel was arguing to the court, and that's what the court ultimately found. So looking at, surely if you take that sentence out of context and insert your own parenthetical, you can make it say whatever you want. But when you look at the entire statement that's being made, counsel was referring to the undisclosed information and whether or not that constituted a public record.
So it's your argument is that when they would say it or these things aren't public records, it's the tally and compilation of the data,
Yes.
not just Childs itself.
It's the information that had not been disclosed.
And if I read your pleadings in the prior case here, your briefs, I'm not going to find something that says this is not a public record, we shouldn't have to disclose it at all.
No, not in the briefs.
With writ to right to ACLU, with regard to Childs at large.
Correct. And actually, the trial court below asked for a supplemental citation to where in the brief the department had said that, had conceded that Childs is a public record, and that was provided to the court. With respect to Director Flanagan's statement, he did make one statement where he said he did not believe that Childs was a public record. If you look at the entirety of his testimony, however, it's clear that he understood that information contained in Childs had to be queried and produced in response to public records requests. If you look at all of the other evidence that was presented by the department from various other individuals who worked within the department and who worked directly with the Childs database itself, all of them acknowledged that this is where DCS's information for public records came from, and acknowledged a duty to respond to public records requests regarding that information. With respect to ACLU claims to have engendered a policy change, that's also not the case. The policy change was to stop responding to informal requests for information and require that they go through the statutory process because of the competing demands on DCS's time. And so, although Director Flanagan did make that one statement, the overall bulk of his testimony and the overall evidence that the department presented and the positions that the department has presented in all of its pleadings in both trial court actions and in both appellate actions demonstrate that the department has always understood that Childs is a public record. The issue is how to get that information available to parties who request it.
With respect to the delayed documents, and maybe you would disagree, but I'm going to assume that you don't disagree until you tell me otherwise. If there was a smoking gun document in those documents, they could substantially prevail on that basis.
I guess I'm not sure what you mean by a smoking gun document.
So let's say that I agree with you that the trial court was wrong to say that the public records finding is enough to substantially prevail, because that's how I read the lower court decision, basically, just that alone. But wouldn't you agree that if some of those post-litigation documents contained some real meat, even though it was a small portion of the overall thing, that would be enough to allow ACLU to substantially prevail as to those documents?
As to those documents, but it was such a minute portion of the litigation. If you look at the Paradigm case, they talk about how long the parties remain adversaries. And from the time they received the last information they were entitled to, it's our position that they and DCS were not adversaries with respect to information.
That would be a basis, as I read it, to say, all right, you can get fees up till that point, but then after that, you don't get the fees. But we're talking about whether you substantially prevail for some portion of the fees, and then it's a separate issue as to how much fees, right?
Exactly.
Okay.
And so, and the issue is,
But
how do you...
just the writ large, I keep saying writ large, I don't even know what that means. For purposes of the big picture, did they substantially prevail? It could be one really meaty document in that post-litigation documents would be enough to find they substantially prevail.
Well, if you look at the federal FOIA cases that ACLU provided to the court late yesterday, they talk about one of the analyses in the federal construct is to look at what is the purpose of requesting the documents. And the department never inquired, and ACLU never indicated what its purpose was in requesting all of this information, other than just a general look into DCS practices. So I'm not sure that there was capable of being a smoking gun in this case, because they weren't looking for anything in particular that we know of.
So under these circumstances, it would just be a quantitative analysis instead of qualitative analysis?
I believe so, because they They have not prevailed on any claims that any of the information that was provided was deficient, and all of their claims regarding the deficiency of the information that was not provided, they've lost, both in the trial court and in this court. So if you look at the overall amount of litigation, the amount on which they prevailed was very, very small.
If you want to preserve some time, you should probably stop now while we're
Thank
taking
you,
a
Your
breath.
Honor.
Thank you, counsel. Now, counsel, you can approach.
Sorry for the confusion. Good afternoon, Your Honors. I'm Keith Beecham. I represent the ACLU of Arizona. As a result of this litigation, a published opinion was issued that directs all state agencies that they must search and run queries in their electronic databases. And not only does that apply to all state agencies, but as a result of this litigation, there's a published opinion that holds that Childs is a public database and, importantly, that DCS must run searches and queries for public records purposes. Prior to the time this litigation was filed,
Your
DCS
opposing counsel just avowed to us or said to us that DCS conceded that Childs was a public record during the litigation in ACLU 1.
That is not true. I mean, it's telling that you can find no citation from the government in which, in the prior to the 2016 opinion, the government concedes Childs is a database. And the real issue here, I think, is what you do with a database. Not only is it a database, is it a public record? Here, I think under examination, I think that they would concede, as they must back in 2014, that all the materials within Childs are public records, and there might be some confidentiality exceptions, et cetera, because to do otherwise would be a little silly. But their perspective was, it's not a public record to which the public has access, because we are not required, under any circumstances, to run searches or queries in response to public records requests. The only thing you, members of the public, get to receive are the materials that we in our own governmental function have decided to extract from that database. The Court of Appeals disagreed with us along that continuum. The Court of Appeals ultimately said they don't have to answer requests that call for analysis, but the Court of Appeals agreed with us on what I think is the significant point, because it's the point that lets the public have access to Childs at all, apart from whatever records the government wants to give you. The Court of Appeals agreed with us that they must run searches and queries. And if you
did DCS contest that all along?
absolutely.
And where?
So, I have my spectacles so I can read, Your Honor. There's a different kinds of evidence about that. One piece of evidence is the Exhibit 25 from the trial exhibits. That is the letter that relates to Children's Action Alliance. This is an example. I'm going to give you a broader example in a moment. But where the Children's Action Alliance had submitted a request, Mr. Espadas, who's the head of the RSU, asked for permission to provide the information. Director Flanagan said, no, don't do that. We want you to be doing other things. And Mr. Espadas said, well, I already did it on the weekend. I got it. Can I give it to him? And he said, no. I think that's an example of the department changing its policy. That's one example. Another example is DCS told us in June, I believe it was, maybe it was May of 2013, that they were going to provide all of the requests, information that was requested in the May 2013 public records request, all of it. And they gave us a time frame for doing it. Those dates slipped. They said they would give us all of it.
Well, counsel, I take your point that there may be documents in the record regarding DCS officials, but in the litigation, what was DCS's position?
I would direct you, I think, to the proposed findings of fact and conclusions of law that they submitted and that we submitted back in 2014. That's probably a good place to see what the parties really wanted, right? Their proposed findings of fact and conclusions of law were adopted ultimately by Judge Oberbilling. If you look in paragraphs 14 through 16 of, this is IR 50A, index of record for the government, there's the title, Child's Information That Is Public, and there are 3 paragraphs that follow, 14, 15, and 16. And the information that they deem to be public in Child's are the reports that they list there, reports they've created out of Child's. Conversely, to answer your question directly, Judge Howe, if you turn to paragraph 14 of that order, it says, in order to respond to, and they identify certain of the requests, DCS would have to query, manipulate, and analyze raw data. Paragraph 15 says, the testimony of Nick Espadas and OSC Hearing Exhibit 42 demonstrate that the querying of data is not a mere search for records, but actually constitutes data analysis. They were arguing explicitly to the trial court that merely searching and querying data in the child's database, and I'll repeat the citation, paragraph 15 of IR 58. The trial, and if you contrast that language about whether you have to search and query with the Court of Appeals opinion that was issued in 2016, they lost. It's clear here that they do not want to search and they do not want to run queries. That's what they said in the litigation. And then we have evidence of that through the Children's Action Alliance example that we have, and also through our own example where, and I didn't really quite finish my example a moment ago, where they told us that they were going to provide all of the information in the May 2013 request. They started providing it. They changed their policy, Director Flanagan did, about whether they were going to provide information out of Child's. They never told us they changed their policy. They never told us they weren't going to do what they said they were going to do in their letter, and they refused to give us the documents, and we didn't get them until after the litigation was filed. Those are 2 examples in addition to what they said in these papers.
But you acknowledge that you did, or let me say, I don't know if you acknowledge, you did not receive any additional documents as a result of our ruling in ACLU 1.
That is correct. None that would be responsive to this public records requests that we had submitted.
And they were running these queries before, even though they asked for this finding.
Yes, there's testimony. I didn't mean to interrupt, sorry.
No.
There's testimony from Nick Espadas that they were indeed running these queries and that that's what they had been doing since he'd been with the department, which was 14 years, and that Director Flanagan changed that. And to get to one of the points one of you asked at some point about the smoking gun or information, in this case, we learned about that policy change only after, over their objection, we were permitted to take the deposition of Mr. Espadas, and we prevailed on a motion to compel to require them to produce what turned out to be about 600 pages of documents. And I'm not talking about public records documents, I'm talking about documents that relate to their policy for producing FOIA requests. And among those documents were the emails that showed us that the policy had been changed. And so as another example of the public benefit from this lawsuit, no one knew that. Children's Action Alliance wasn't told that they weren't getting their documents because of a policy change. They just didn't get their documents. And unlike Children's Action Alliance, we didn't get all our documents, but we got 500 pages of documents. Why? Because we filed a lawsuit. Before I close out this area, I believe that Ms. Williams said that ACLU did not argue in the trial court that Child's was a public record, and that's simply not true. I would direct you to our proposed findings of fact and conclusions of law from 2014, which is IR 55. And if you look at paragraph 44 of our proposed findings of fact and conclusions of law, we say, at issue is whether the data contained in the child's database constitutes a public record, and secondarily, whether the process of extracting that data somehow creates a basis for not producing the records. This issue was squarely in front of the court in 2014.
My brain's a little slow sometimes, so I want to jump back to something you just said, because I think I've processed it now, and I want to make sure I understand it. You said that the policy change from query to no query back to query, kind of, that you discovered during this litigation could provide a basis for you substantially prevailing. Is that correct?
Correct, Your Honor.
But I don't read the lower court opinion as relying on that change. The lower court opinion seems to be focused solely on the public records aspect of Child's, which I'll just tell you, as I read it, seems flawed. That I do think that at best the DCS was, there may be some ambiguous statements, but they were providing and not really contesting whether the Child's itself was a public record. Now, querying it may be a subset of that. So how can we affirm if the Superior Court relied solely on one thing, and you're now arguing something slightly different.
I'm afraid I'm not sure I understood your question. In the Superior Court decision you're talking about is the one that has led here, Judge
Yes.
Goss's opinion, not
Yes.
the 2014
Yes.
decision, right? So Judge Goss said that whether Childs was a public database was the crux of the case, and that's the language that's in the Ford case.
Yeah.
So he did say that, and I thought your question to me was that you thought he didn't. So that's why
No,
I
no,
think I
I'm saying he
misunderstood your question.
did, but
Okay.
you seem to be arguing that, but it's also the fact that there was this policy change from whether they had to query to not querying to back to querying.
I would
provide
describe the
basis.
policy change as ancillary as compared to the big picture issue of is Childs a database and must you search and query? If that answers your question.
Well, sort of, but if I don't read Judge Goss's opinion as relying on the must you search and query prong of it.
I agree.
You do?
And, well,
Or
I think
I'm
that,
sorry, you agree or you don't agree?
I think I don't agree. I think that I don't think Judge Goss shaved it quite that fine, frankly. And I don't think it matters to some degree because this is an area, although it was referred to, I think, in Ms. Williams' opening remarks as an issue of law, this is really a factual issue for which he has discretion. I mean, it's an issue for which he has discretion. And
Assuming he
so,
applied the correct standard.
right, so assuming he did, which I think he did, and so the question now is there any basis for the decision that he made? And I think the answer is yes. But apart from the bases that he cited, if there are other bases in the record, I think that would be relevant. The real point is, I don't think you are supposed to sit here and revisit that. I think that's his job.
Let me try and ask you the converse of one of the questions I asked your opposing counsel. So I think you could clearly find the smoking gun in there based upon a single document if it's a good one, and that's enough to provide substantially prevailing. What if the contrary is true? Is all 500 of those pages were just fax cover sheets that don't add anything to the substance of what you were asking for?
Yeah,
Isn't that
there's-
alone enough, even if you might have a change of policy, if you really didn't get anything out of it?
I think the big picture here is what's the legislative intent of the statute, and the trial court is supposed to try and fashion its decision to comport with that legislative intent. There's never been cases that say it's a page count. There's never been cases that say it's X number of documents versus Y number of documents. So to do that would be, I submit, a change in law. The issue is the legislative purpose of trying to further the public interest and the statutory language that's there about requiring government agencies to produce public records. And the trial court can and should have the discretion to decide whether on the particular facts presented, a particular case does that or doesn't do that. And these are gray areas, and there's things that go all over the place. The Paradigm case, for example, I don't think has really any application to us. Paradigm has the reaches to sort of establish the rule that they established because Paradigm is the odd situation where the trial court ordered the assessor, the government in that case, the tax assessor, to produce documents beyond those that were requested by the public records request.
I agree with you that Paradigm's not 100% on point or controlling, but there is some language in there that seems to support the DCS's position, at least as I read it. And specifically it says a party may substantially prevail only to the extent an action is necessary to accomplish the purpose of an original records request. So wouldn't that's why I was going back to, if all that you got out of those 500 pages was a bunch of receipts for documents already received, I'm just trying to pick a worst case scenario. Wouldn't that, under Paradigm's language, wouldn't that defeat your substantially prevailing argument?
It would if we hadn't prevailed with respect to whether Childs is a public database and that they have to search and query it. If we hadn't prevailed on that issue and gotten that language from the Court of Appeals,
What's your cite for
then
that
we wouldn't be able
proposition?
to get any fees past June or whenever we got those records.
Right.
I don't think. I mean, you arguably at least. I'm not conceding that. I'm just saying I get your point. But from our perspective, the language that you're talking about in terms of achieving the purpose here was to get access to the data in Childs. That was
Which you got.
Which we got, and which is why we prevailed. And whether we let me back up and make real clear about one thing. The RSU, we were busy, all that stuff in terms of why we weren't getting those documents. That relates to the material we didn't get.
I agree
The
with you
things we
completely.
got didn't come from the RSU. Our requests, for the reasons that are in that Court of Appeals opinion, weren't granted, but we did get access as a result of that Court of Appeals opinion. We will have access, and equally and more important, members of the public will have access to the child's database, you can now submit a public records request and get those materials. That was the purpose of this litigation. I mean, obviously, we have public records requests that are some distinct ones, but when you look at the overall purpose, and that's partly the reason that I provided those other cases from...
What's your statutory authority or Arizona case law authority for the proposition that obtaining that shift in policy for future cases, even though you had already been vindicated on your case, will allow it?
I don't have an Arizona... There's not an Arizona case that's tackled that one way or the other.
I know, it's amazing how little there is, isn't it?
Yeah, there is. And you know, you can look at the FOIA cases, but our FOIA statute is broader than, I mean, you know, Arizona's public records statute is broader than FOIA. That's, I think, Hornbook law here.
But FOIA, federal FOIA has a specific definition of what substantially prevailed is, which seems to be broader than what Arizona courts have done so far.
I think it's more complicated, but I don't think it's broader. I think Arizona courts just
since
haven't
Arizona
been,
courts have done almost nothing.
Yeah, they haven't
that's not
been
fair.
just haven't been confronted with the issue really in the way that the federal courts have been. What I did, the reason I submitted those cases was, if you were to look at FOIA law, the standard that is employed there frequently incorporates notions like the public interest, et cetera. I don't think we need to rely on that here.
I don't read Paradigm in all. We can just disagree. I don't read Paradigm as relying on that D.C. Circuit case. It notes that the lower court relied on that D.C. Circuit case, but it never affirmatively adopts it. So I don't view it particularly persuasive one way or another with respect to federal authority.
That's fair enough. I don't particularly disagree, and I really provided those cases because I wasn't sure what y'all's view on that would be, and if we were going to talk about FOIA, I wanted to at least have you guys see the cases I was referring to.
But counsel, so what you're saying is, even though you didn't receive any additional documents, which is the purpose of why you filed the lawsuit, was to get the documents, to get information that you wanted, even though you didn't get anything else after getting that victory in the Court of Appeals, that you still substantially prevailed.
That's correct, Your Honor. I mean, that is absolutely our
So
argument.
it's just a pure legal issue. As long as we prevail on the legal issue, our receipt of any actual information doesn't matter.
I don't know that it's a pure legal issue. I'm not sure I would agree with that. I think it's probably mixed in my view in terms of the trial court judge needing to look at the request and looking at the record to try to figure out what we were really trying to do. But putting aside whether it's a legal or factual issue, that is our position. And I'll note at footnote 11 in Paradigm, they talk about there are instances where it's not squarely on point with what we're talking about here. But where if it would be futile or if there's a change in policy or the government has made clear to you that they're not going to produce a particular kind of record, that there's no that they wouldn't have this limitation that they adopted in that decision. I mean, I think footnote 11 of Paradigm makes clear that the analysis that I'm arguing for would be adopted by the Paradigm court. But Paradigm was just different because those requests were something the court imposed, not something that the parties did, and it didn't have the same public policy opening up the child's database component to it. I don't know if that makes sense, but really no court has tackled exactly what we're talking about here, but I think it's consistent with the purposes of the statute to get back to how I think what ultimately guides this decision.
I don't know if you want to talk about this, but since I get to ask the questions, I'll ask it. As I read the record below, the trial court essentially awarded you all the fees for almost everything, right?
Correct.
For at least for the documents, they quit being adversary once they disclosed them. Arguably, they weren't adversary as to whether child's, by the time you got to the litigation for the Court of Appeals, they weren't adversary to you as with respect to whether they needed to run these queries anymore. Now, they had changed their mind and gone back and forth, but they were at least saying, we will give you documents from Child's.
That's actually not, at the time we filed the complaint, they were not giving us documents from Child's. We didn't know there had been a policy change and they weren't. And from then up until that Court of Appeals decision was issued, they were not willing to run searches and queries in Child. I'm not sure if that answered your question.
It may.
I cited you some of the language from their findings of fact, but they cannot point to any document and they cannot point to any evidence where they were willing to run searches and queries in Child's for public records until this decision was issued in 2016. And so I don't think it's arguable. I think it's pretty clear from our evidence.
We'll hear what she has to say.
And and the other point I would make about whether it's clear or not is I think that's the trial court judge has looked at all that evidence, and there's a fair amount of it in terms of depositions, discovery, and the transcript below. But they weren't doing that. They weren't running searches and queries. They weren't willing to do that.
after that opinion, did they run a search and query in this particular matter?
That's a very interesting question, Your Honor. I don't know. It's very interesting. On the remand, the government elected not to come forward with any witnesses, so it would have been helpful for them to come up with a witness that says, you know what, Your Honor, this public policy argument that Mr. Beechman's making doesn't make any sense. We actually were willing to run searches and queries. Look, here's a declaration from the person who was doing it in 2016 or 2015 before this opinion was issued.
How did the post-litigation...
They didn't do that.
Does the record reflect how the post-litigation documents were generated if they weren't running queries?
The post-litigation documents did not come out of Childs. That's kind of my point with respect to the RSU information being irrelevant. I mean, all of the data initially might be in a computer somewhere, but what they gave us, the 500 documents that we got in the 2 months after, those were reports that they had already generated.
But the remand was specifically, okay, then I'm really confused, or maybe I shouldn't be this confused, and I will ask if the presiding will let us go a little longer here.
Please, of course.
If the post-litigation documents didn't come from Childs, how can Childs, based upon the law of the case on our remand was specifically remanding to whether you substantially prevailed on the post-litigation documents and whether those were timely produced. Mm-hmm. How can Childs, any ruling from the Court of Appeals on the Childs issue, provide a basis for finding you substantially prevailed when the remand was limited to the post-litigation documents?
I don't think the remand was limited to the post-litigation documents. I think that what you're thinking about is the promptly produced issue, not the attorney's fees issue. They're different issues. And so the remand is limited on did they promptly produce those post-litigation records. That's one box. The other box is did we substantially prevail in litigation? And there's no limitation on that to be limited to.
But the litigation, you can only file the litigation based upon documents not being produced. And if there were no additional documents produced, how could you have prevailed?
Well, we filed litigation on documents that some of which were produced. And I guess I'm not sure I understand your question, and I feel like it's an important one. Yeah. But we filed the litigation to get access to material in Childs, not access that the government had already extracted. We got some documents from them, and we got ultimately the goal we had in the case, which is to require them to run searches and queries in the Childs database so that we and everyone else could see what's in there.
But to follow up on that, none of the documents we got then came from Childs.
None of the documents came as a result of new searches being run in Childs. I would say that. I mean, at the end of the day, every piece of information they have is probably in Childs. They extract some of it, package it up, and then give it to, put it in public reports, for example.
I'm going to read to you the remand on ACLU 1.
Okay.
ACLU's request for an attorney's fees. They go through, the court found ACLU had not substantially prevailed. We, however, ruled in part in ACLU's favor, and we are remanding to the Superior Court to determine whether DCS promptly provided the ACLU with the post-litigation documents.
Could I trouble you to add what paragraph you're on, Your Honor? I'm sorry, I didn't quite catch that.
That would help, wouldn't it? Just pick a page at random and just look.
I assume it's toward the end, but...
It's paragraph 37.
Thank you.
We have, however, ruled in part in ACLU's favor, and we were remanding to the Superior Court to determine whether DCS promptly provided the ACLU with post-litigation documents.
I think when the court refers to it ruling in favor, ruling in part in the ACLU's favor, that is not referring to the post-litigation documents. That's telling the court to go look at the post-litigation documents. The ruling in favor that we got doesn't relate to the post-litigation documents. It relates to precisely what we are arguing about here in terms of reversing the Superior Court's order, and I'm looking at paragraph 1, that the electronic database doesn't have to be searched and queried. That's the ruling in part in our favor, I think, that they're referring to here. They didn't already decide, they didn't rule in our favor and decide that those 500 documents were or were not promptly produced. They just simply told the trial court, you missed it, it's a do-over. What they ruled in our favor on was, this is a public record and you have to search it. So I think that actually, I read that as supporting the construction that we have, that we're offering to you.
Okay, thank you.
Thank you, counsel.
Thank you.
Sorry for holding you over.
And Ms. Williams, we'll give you two more minutes for rebuttal. If you just wait for the bailiff to accomplish that. Thank you.
Thank you, Your Honors. To clarify a few points that were made, you will not find anywhere in DCS's pleadings that they say Childs is a public record. And the reason for that is that's not what we were litigating. What we were litigating was, are the outstanding requests public records, requests for public records, or are they outside of the scope of that analysis? Had ACLU said, we are here to litigate whether you ever have to query Childs, the department would never have said it doesn't have to query Childs at all, because that's the only way to get information out of Childs. And if you go back and read the declarations and the testimony about how things were broken down into Category 1 and Category 2 types of information, the idea was that the Category 2 types of information that ultimately ACLU was not entitled to receive required more than just a simple query. They required manipulation of data. And that's what the department was objecting to. I would also point out that there was no change in policy. They continue to refer to this email as a smoking gun, to use your words, as demonstration that there was
Please
some...
don't feel constrained by my words.
Sure, I can come up with something else, but it wasn't that. The email was simply a reminder by the director to his staff that the way things used to happen here informally, where someone from Children's Action Alliance could call up and ask for information, can't happen anymore. We have too many competing demands. Make them make a formal request. And in fact, Children's Action Alliance did so. And so the issue was not we're changing a broad policy. The issue was we're going to do things by the book.
Respond to his point about the proposed findings of fact and conclusion of law, where you guys specifically said we're not required to query.
Again, in hindsight, would I wish that we had been clearer in that language? Definitely. But I think what we were litigating and what the department intended by that language was we are not entitled to do those Category 2 types of analysis, that we are not required to, or that DCS was not required to manipulate that data beyond simply pulling it out of Childs. To the extent that DCS had information that was responsive, that it could ask the Child's database how many children were in foster care in this month, how many children even between these ages were in foster care in this month. The department provided that information, and that information came from Childs. That's where it comes from. The department had no problem providing that information. It was when it came to statistical analysis of that information, percentages, things like that, that the department said this is beyond the scope of what we're required to provide, and we cannot provide that under these circumstances. At another time, circumstances were not such that the department was being completely dismantled and rebuilt. Perhaps the department could have done some of that statistical analysis, but it would not be required under the public records law. And I would point the court to the Division 2's holding on paragraph 27 of Paradigm. They said that a party substantially prevails only to the extent the action is necessary to accomplish the purpose of the original records request. All of the successes that ACLU is claiming that support its substantially prevailing in this has nothing to do with the original records request. They did not prevail in terms of that records request. And so to that extent, and I think their federal law supports that when they prevail on a different theory, that's not part of the computation of attorney's fees.
Am I right in that they're only entitled to attorney's fees to the extent a request has been deemed denied?
Correct.
Okay. And the only way a request has been deemed denied is if, in this case, based upon the remand, was if they were unduly presented.
That's correct.
Okay.
And
so then it's only the post-litigation documents, again, that were deemed denied, in this case, that they would be entitled to fees for.
correct.
And if none of those cases, none of those documents were from Childs or result from a query from Childs, how did the Superior Court decide in favor of allowing fees?
That's a mystery to the department. The department did not present additional witnesses at the remand hearing because the burden was on ACLU to show that they had substantially prevailed. I would note that to the extent that they're claiming that they prevailed by getting this overarching public interest finding, their remedy or their request for fees doesn't fall under the statute here, ARS 39-121.02. It falls under the Public Attorney General doctrine, which they've never claimed. So to the extent that they're arguing that by pursuing their individual public records request, they've benefited the entire state, they haven't sought the appropriate remedy for that.
Thank you.
Council, your time is up. Thank you both for your arguments today. We'll take the matter under consideration, issue a decision in due course. Thank you. We stand adjourned.